On behalf of the Friends of the Third Branch, thank you for being here to talk about some of the most important things facing our government, really, and the practice of law in a generation, probably, if not more. My name is Natasha Jones. I am an attorney at Boone Carlberg here in Missoula. I've been practicing law there for 25 years. I'm from Great Falls, came to the University of Montana for undergraduate and law school. I am not officially associated with the Friends of the Third Branch. I'm here as your moderator today, and I'm here to make a confession to you all. And that is that before this last legislative session, while I had practiced law for more than 2 decades, I had never contributed, paid attention, educated myself, or participated in the legislature. And so that is on me. And I was ashamed of that this year when I found myself as a very concerned citizen and a very concerned lawyer about what was happening in the interactions of our branches of government here locally in the state of Montana and nationally as well. I am also on the executive board for ABOTA, which is the American Board of Trial Advocates. And as a part of that organization, we as a body decided that we needed to raise our voice and participate at the legislature. And on behalf of that organization, which is not associated with defense lawyers or plaintiffs' lawyers, but is an organization that's devoted to preservation of the jury system and of the independence of the judiciary. We spoke against multiple bills, and I did that. And I'm here to share with you some observations from my own personal experience. One, it was very easy. So I was shocked at how easy it was for me to register and provide testimony remotely. It is simple. The barriers to participation are very low. And I was ashamed of myself that I had not done that before. When I participated, I was shocked at the lack of participation by lawyers across the state of Montana. These were incredibly important issues that were affecting us all. And some of these bills, in my personal view, were woefully misguided. And yet, very few people, and I mean less than 5 people, were coming to these hearings and providing testimony. I was shocked at the lack of participation and ashamed. My last observation is that, well, 2 others. One is the folks that do show up are regulars. So I was new. I had not been there before, but every time I showed up, it was the same 4 or 5 people. And I think that those folks that do participate add great value, but when it's the same people coming to every single hearing, I wondered how effective those voices are and how useful it is to our legislatures in actually asking them to pay attention if it's just the same people over and over again. I wanted there to be more variety, and I wanted more people to raise their voice. And the last thing I would tell you is that they didn't seem very interested in listening. And since then, and so I found myself wondering, maybe the reason people aren't here is because this doesn't matter. And but I'll tell you what, I came away with it thinking it does matter. And what is wrong is that I hadn't participated sooner, that I hadn't met more participants in the process, representatives, legislature, that I hadn't raised opposition or views before the moment where you only get 2 minutes to speak, and many of the people have already made their decisions. And I've decided it's very important. And so our hope today is that we can engage in a dialogue about how do we improve the operations of our government? How do we engage in more civil dialogue? How do we educate individuals on the civics, right? These are lessons that we learned in high school and in college and in law school, and some of those lessons need to be revisited. And then how can we get to know one another? so that when we are having these conversations, they're not shouting matches, but they are thoughtful, deliberate discussions that are meant to aid our state of Montana and our local communities in forwarding very important issues. With that, there's a reason that we have so many people that signed up for this, CLE. It's so important. I want to thank our presenters. I think this is a difficult time to say yes and then just say, I'm going to take questions from anybody about anything. And so we'd ask that if, when you do make questions in the room, that we engage in thoughtful civil dialogue, even if you may disagree with the position stated by some of the speakers. And we thank them for their service. So every one of these presenters today are in the trenches, and it is a very challenging time to do this work. And so we thank them for their work. I also want to thank the Friends of the Third Branch. It is an enormous task that very few people took on. If you get on their website, there's a report, the 2025 legislative report, just from the last session, to give you a sense of the work that those people are engaged in. And there's, we're talking about 4 folks and some others, because they didn't have enough help. They really took on a huge burden for our profession in managing what was happening in Helena, disseminating information, educating, and then advocating for the rights of us all. So we owe them a deep thank you and our gratitude for their work, but we need to step up and help them in the work that's to come. And so at the end of today, I'll say this again, but I'm going to start by saying we need all of you to be more involved. We need you to consider running for office. We need you to consider meeting and speaking with your local representatives long before the day, the minute, the hour of their decisions. We'd like you to consider testifying and educating. Maybe educating more, because educating starts now and it is all the time, and it's not just during the next session. And then testifying when it matters. And it doesn't have to be in opposition or for or against. It can be as an informational witness, just to provide a perspective that should be heard. And lastly, we want your money. So if you go on the website for the Friends of the Third Branch, you'll find there's a donate now button on every page. And there's good reason for that, because the work they did was very expensive and it required professionals who they had to pay real American dollars to. And so they need your support financially. And this work is very important. So thank you for being here. And with that, it is my pleasure to introduce our first speaker today, Ann Sherwood. Ann's going to provide a legislative update. So look back with some information about what has occurred. Ann has a master's from the University of Montana, before she graduated here also from the School of Law. As a law student, she received the American Bar Association prestigious Steiger Fellowship in Consumer Protection Law. While at law school, Ann worked for the Montana Office of the Commissioner of Political Practices and in the Attorney General's Office in the Consumer Protection Division. She was also a member of the National Moot Court Regional Championship team. She joined Morrison Sherwood Diola right after law school to practice alongside her father, Rick Sherwood. The focus of her practice is on helping Montanans in the areas of consumer protection, employment, personal injury, intellectual property, and constitutional law. Please welcome Ann Sherwood.
Thank you, Tasha. I would like to thank everybody for being here, both in person and online. I was told we had around 500 people register for this, so that's awesome. And I think that speaks to how important this issue is. And I want to second everything that Tasha said about participating and contributing in the best way that you can. As she said, my name is Ann Sherwood. I'm an attorney. I practice law in Helena. And I was recruited by the Friends of the Third Branch, specifically Betsy Brandborg. And if you know Betsy, you know she's very hard to say no to. She asked if I would be the public face of the Friends in these legislative committee hearings. So that was my job. I was the public lobbyist. I would show up at 8 a.m. to a committee room where there were 5 other people sitting in chairs, and I would get to give my 2-minute spiel about why the Friends of the Third Branch thought that a piece of legislation was ill-advised or should be reconsidered. I can tell you that the Friends testified in around 16 hearings over the course of the session, that we were actively tracking 44 bills that directly impacted the judiciary. Of those 44, 31 failed. 5 bills passed. Okay, so my job is to talk a little bit about the ones that failed and focus on the ones that passed, because they're going to have impacts on the judiciary going forward and also the practice of law. It's also very timely because a lot of these go into effect on October 1, 2025. So if you are a practicing attorney, I would be paying close attention here. Of the bills that failed, there were 5 that addressed judicial elections and making judicial elections partisan. And the frequent metaphor that was tossed around the Capitol was, it was like whack-a-mole, just trying to keep track of all these bills. As soon as we thought one got voted down, another one popped up, and it was kind of a game that way. So I would argue that was one of the hot topics of the session. It's definitely going to come back in some form. I'm sure everyone, if you signed up for this, you're probably well aware that that's coming down the pike. It definitely became more of a bargaining chip than anything, I think, as far as using it as a way of leverage to get other things passed or maybe not passed going forward. Of the legislation that came about regarding the courts, a lot of it came from a special committee of the Senate that met the summer before the session. It was called the Senate Select Committee on Judicial Reform. There were a lot of the same people bringing these bills in the legislature. We heard a lot from Senator Emmerich, Senator Usher, Senator McGilvery, Representative Millett, Representative Overstreet. They were often bringing these bills on behalf of the special committees. Themes that we saw in these bills, there was a definite desire to atone for specific Supreme Court cases. So there would be a bill that was a direct response to the holding in a particular Supreme Court case, and that case would come up in the committee discussion. That's how we knew it was in direct response to that. That happened on at least 3 bills, and none of those bills ultimately passed. Also, we saw a lot of judicial reform bills that were taken from other states. So judicial reform is something that's happening on a national level, and you guys are going to hear about that later this afternoon. But a lot of the legislators in Montana saw what was happening in other states, and they brought it here to Montana. We saw that with the Chancery Courts, or the Governmental Claims Court bill. That was a big one there. Also, the Senate Bill 45, which passed, which is the Judicial Standards Evaluation Commission, which I will talk to you guys in a bit about. I want to set the stage as far as what those committee hearings were like. I mentioned earlier that I only got 2 minutes to speak, and often that was it. It was discouraging that there was a lot of talk of reform and serious reform, and not a lot of actual talk about the need for the reform or how the reform would actually work. It was an idea based on a perceived need, and there was 2 minutes of discussion about it, and that was it. Oftentimes in these committee hearings, the Friends of the Third Branch, we weren't saying that we didn't need to look at the issue, but we were asking for is a deeper look at the issue. And we saw that at the end of the session, especially regarding the Governmental Claims Court. There is going to be a committee that's going to be studying whether or not there is a need for a specialized court in Montana, but that was only one issue, and there were many. Some of the bills that did not pass had to do with revising the grounds for impeachment of judges, removing Supreme Court original jurisdiction for ballot review, allowing legislative leadership to vacate a writ of mandamus, making Supreme Court deliberations open to the public, and revising injunctive powers of the judiciary, exempting lawyers serving in certain public offices from professional disciplinary measures for actions taken while in office, the Court of Chancery, and the Governmental Claims Court, as I mentioned before. So that was just a very quick overview of the flavor of some of these bills that we're seeing. And going on to the bills that did pass and that are going to have a direct impact on both practitioners and judges. So first on the list is Senate Bill 30. The short title is that it tightened recusal requirements for judges. What that means is it talks about the rule of necessity. So the rule of necessity is a legal doctrine that says that if there's no other options for a judge to sit on a case, a judge who has an apparent conflict can still sit on that case. And as you might imagine, it's very rare because there's usually another judge somewhere that has less of a conflict that can sit on a particular case. So Senate Bill 30 says that a judge may not use the rule of necessity to avoid recusal when there are other judges available with less of a conflict. That's already happening. We think kind of the impetus for this bill is it might be used as a way to argue that a particular judge should not have stayed on a case due to a perceived conflict. There was a lot of talk in these legislative committee hearings about judges acting improperly. Judges, I heard the word corrupt thrown around. I heard judges need to be reined in. There's a general sentiment by some members of the legislature that the judges and the judiciary are too independent and have operated without proper oversight for too long. And so that's what has spurred a lot of these legislative reforms. So on a deeper level, the purpose is likely to make arguments that a particular judge should not be sitting on a case because of some alleged conflict. I want to point out that when I was speaking on a lot of these bills in my capacity as an attorney, oftentimes they didn't want to hear from attorneys. And I don't mean to say that to discourage people from speaking, because we absolutely would like to have you there. But it was more about what I spoke of before, which is the individuals that are actually within the legal system every day. They think that we are too close to it, that we are foxes guarding the hen house, that we are going to look out for our own. So that's why we're opposed to these reforms, because it's going to throw too much transparency onto this system that we've enjoyed secretly for so long. The next bill that passed was House Bill 39. You guys probably heard about this one. It made waves in the news. Political parties may now fund judicial candidates. And I heard through the grapevine that this bill only passed because a particular legislator accidentally hit yes when he meant to hit no. But as it is the law in Montana now. And it's interesting to note, though, we're not sure this is going to make too many waves right away, because accepting a judicial candidate accepting money from a political organization is still prohibited under the Judicial Code of Conduct in Canon 4. However, for your information, the aggregate per limit for statewide offices is about $84,000 for a political party per election, and then district judges, justice of the peace, that's about $2,250. So it's a drop in the bucket compared to the millions of dollars that are likely to be spent through independent spending. But again, we don't think we're going to see too much of that in this next election, given those existing judicial canons of ethics. Senate Bill 41 has to do with the random selection of a judge post recusal. So if you're a practicing attorney, you're probably well aware of the rule that you all get one opportunity to bump a judge for free, so to speak. And in the past, when that would happen, you would be randomly assigned a new judge, and that judge will be within the district that you are already in. I practice in the 1st Judicial District. I'll use that as my example. If I was filing a case there and I got Judge CLE and I wanted to bump her, then I knew I was going to get Judge Abbott or Judge McMahon or Judge Menahan. That was my pool of judges I knew I could possibly get. Senator Emmerich originally brought this bill. He wanted totally random selection from every judge in the state of Montana. That would mean that if I filed in the 1st Judicial District and I wanted to bump Judge CLE for whatever reason, I could have gotten Judge Leslie Halligan from Missoula, or I could have gotten a judge in Billings or a judge in Sidney, Montana. That's how big the pool was. And we talked about that in the legislative hearing, and we discussed that that was practically unworkable, that it was already a random selection of judges within the district. And so they modified the final version of the bill. It says that the random selection must ensure that the new judge is, quote, reasonably close geographically to the district in which she filed. So they've left that up to the court administrator to determine what those rules are, but just know, starting October 1st, 2025, if you guys are filing in a particular district, you may not be guaranteed to get a judge in that district anymore, thanks to the new rule here. We do think that this rule violates the Constitution in a couple of ways. We've got the separation of powers under Article 3, Section 1. There's also Article 7, Section 2, Sub 3, that says the Supreme Court may make rules governing practice and procedure for all other courts. And the rules are subject to disapproval by the legislature, which they did try to do also. They tried to pass a resolution disapproving of the most recent Supreme Court rules. So that takes making rules that govern courts out of the hands of the courts and puts it into the legislature, which we think is problematic from the separation of powers standpoint. Next, we've got Senate Bill 48, which is revised laws related to judicial standards complaints. This is actually a very short bill. The Judicial Standards Commission would receive complaints about judges from members of the public, and in the past, those complaints were completely confidential. The purpose of this bill was to allow a citizen to make their complaint about a particular judge public at any time they wanted. And it's likely that we are going to see judicial standards complaints being made public conveniently before an election where a particular judge is up for office. And there, of course, is no way to ferret out meritorious complaints from frivolous complaints, but there's likely going to be a lot more press about whatever complaint a particular judge received, and that press is going to come out right before that judge is up for election. That was a new one. The biggest one was Senate Bill 45, which created a Judicial Performance Evaluation Commission, which is a mouthful, and it's not to be confused with the Judicial Standards Commission. But the Judicial Performance Commission, the entire focus is to have evaluation of judges be completely independent from the judicial branch. So the legislature established an independent commission with 11 members who are unpaid, and there are 2 nominated by leadership of the Senate and the House. There are 3 that get to be nominated by the Supreme Court, the Chief Justice of the Supreme Court, but only one of those may be a practicing attorney. And the governor gets 4 appointments, with only one of those may be a practicing attorney in the state of Montana. So again, they really don't want attorneys policing themselves. And the commission is going to hire a third-party firm to conduct surveys of judges and of certain constituents of judges, which would be attorneys who practiced in front of that judge, the jurors who have served on juries in front of those judges, and court staff who have worked with the judge. They do not interview litigants at all. So I'm not sure how they're gonna treat pro se litigants. But they're going to interview that cross-section of people. They're going to ask those people various questions about the judge, such as the judge's legal ability, understanding of the substantive law, adherence to precedent, clarity in writing, judicial conduct, courtesy, preparedness, fairness, open-mindedness, avoidance of bias, and their fidelity to the Montana Constitution, including the separation of powers. That's just a short summary, but they're going to hire a third-party firm to interview people and issue a numerical number for a judge, and the judge is going to receive both a midterm and a final evaluation. The evaluations are confidential unless and until a judge files their candidacy for office, and then at that point, the evaluation becomes public. I also want to point out that part of this bill is they're going to hire courtroom observers to sit in the courtrooms of the judges who are up for election and rate them on these particular criteria. The commission is left to its own devices to come up with who these observers are, what training they receive, whether or not they have to be in person, anything like that. But as you can imagine, that's a very subjective standard, and these evaluations are likely going to be a battlefield for judges going forward, because nothing is going to stop someone who receives a disfavorable ruling from a particular judge from going after them through this judicial standards commission or evaluation commission. So we're going to expect to see a lot of this as it goes forward. I don't think that this commission will be up and running for the upcoming Supreme Court election, but it certainly is going to be there soon after. The commission received $1 million, split $500,000 this year, $500,000 next year to complete its mission. So I have 4 minutes. I will leave it open for questions, but thank you all again for being here, and we really value everyone's attention to this issue. Are there any questions?
Yes, Zach Bolheim from K-PAX. You mentioned that a lot of these bills are coming from other states, but I'm curious to know if there's a larger national organization bringing these down to the states, or if it's just state legislatures crafting them themselves.
That's a great question, and I assume that a later presenter is probably going to be able to talk more about that. But it's all part of a coordinated playbook. Who the actors are behind the curtain, so to speak, it can vary, but I think it's also no coincidence that there's a lot of similarities between all of these bills, and there is a coordinated effort on a national scale to see judicial reform.
And we have an online question.
Oh, I thought we couldn't do that.
Well, we can now. With the new emphasis, is it possible for an attorney who wants to force substitution of a judge to make a donation to that judge's election committee, even if you don't support that judge?
I don't know if I followed all of that, but it's always possible for an attorney to contribute to the election campaign of a judicial candidate. I think it was last session, there were some rules put in place about that, but I will defer on the specifics. Yes.
Does Senate Bill 45 apply to all levels of courts?
It applies to district court judges and the Supreme Court, yes.
But not the limited courts? But not the limited courts?
I don't believe so, no. All right, thank you.